My name's Luke Gittos. I'm a paralegal for Humans Solicitors, and I write about the law for Spiked Online, and I'm also founder of the London Legal Salon. So just to say a quick word, if I may, about the topic of this evening's discussion. It's really focused on the use in recent case law of the Equalities Act to what, in some people's view, has amounted to regulating discrimination. A number of cases have come before the UK courts with claimants seeking compensation for being unfairly discriminated against. And whilst a lot of people have seen this as a sort of positive landmark in terms of equality and a sign that the UK is becoming a more equal country, it raises a lot of interesting questions about the relationship between the law and social change. In a recent case, the two hoteliers who turned away a homosexual couple on the grounds of their own religious belief were successfully sued by that couple and were able to claim £3,600 compensation. And again, there was a cheering of this decision as a landmark for a society that has become a lot more tolerant of homosexual relations. But on the other side of the discussion were a group of specifically religious organisations who seem to suggest that equality legislation is in fact the end of a tolerant society and one in which we are forced to effectively regulate against people's discriminations. So that's really the setting of this debate. I'm just going to say a quick word to introduce our panel. It's a very illustrious panel. Many of you will know David Allen Green, who sat to my far left. David is the legal columnist for The New Statesman and is an eminent blogger under the name Jack of Kent. I'm sure you all know who he is. So we're really grateful to have David along. And it's always great to have someone who appreciates the relationship between the law and politics in a way that David does. So we're really grateful to have David here. Sitting to my immediate left is Wendy Kaminer. Wendy is a long-standing friend of the Battle of Ideas, and it's a real privilege to have her on this panel. She's a writer for The Atlantic magazine and has written more books than I can care to name. So thank you very much, Wendy, for being with us. Sat to my immediate right is Alex Dean, who is the director of Big Brother Watch, and he's also director of public... are you going to tell me that Big Brother Watch is...
No, I'm no longer... That was about 3 years ago, but don't worry.
It's all old CV stuff. But he's now Director of Public Affairs at Weber Shandwick. He's also a council member for Farringdon Without, which is apparently at least where I work, is our local constituency. So I'll be probing you on what you've done for the community after the session. And to my far right is John Fitzpatrick, who is Director of the Kent Law Clinic, who provide pro bono legal services for a wide number of legal cases, including immigration. I'm not so sure if he's worked on the Equalities Act, but he certainly is providing a vital service to those who require legal assistance, and has written prolifically on the law for Spiked Online and for others. So we're really grateful to have John here. So that's all I'm really going to say. What I'm going to do is ask the panel to speak for 5 or 6 minutes to start off with. Once everyone's spoken, I'll ask some questions, and then we'll throw it out to you, the audience. So, Wendy, would you mind getting us underway?
Sure. I think I'm going to dispense with my prepared remarks, so I'll ask your forgiveness if I seem to be a little bit disorganized. I wanted to begin by addressing what Luke started off with, the controversy over your Equality Act. It's interesting to me from an American perspective because, of course, we've had civil rights laws prohibiting discrimination based on race, sex, religion for 60 years now. We had landmark civil rights legislation passed in 1964, which barred racial segregation in public accommodations and public education. Racial segregation and public segregation was prohibited by the Supreme Court in 1954. And when I hear about a case like the one you described, where two people who, as I understand it, ran a bed and breakfast, is that right? Yes. Two people who ran a bed and breakfast were prosecuted under your new Equality Act?
Sued. A civil claim.
Okay, so it was a civil prosecution because they refused to rent a room to a gay couple? Was that the... I shake my head with wonder at that. I would have represented the couple. I think if this was an owner-occupied establishment, they have every right to rent or not rent to whomever they choose. And in fact, that's the way American law works, which is why this seems to me a fairly easy problem to solve. And it has to do with where you put the boundary between public and private. When the 1964 Civil Rights Act was passed, and again, this was the law that prohibited race discrimination in public accommodations, among other places, and in employment. It also extended to race, religious and sexual discrimination. But when the law was passed, the segregationists, Southern segregationists, who were violently opposed to it, claimed that it violated their associational rights, which is essentially the claim that's being made here. And so there was an exemption put into the law for, this was in the public accommodation section, for owner-occupied establishments like bed and breakfasts, which rented, I think the number was 5 rooms or fewer, but whatever the number was, I mean, that's an arbitrary number. You can pick your number. But the point was to protect owner-occupied rooming houses or bed and breakfasts from the reach of this law, because in fact, the associational claim that was being put forth by these segregationists was not frivolous. It was not entirely frivolous, especially as it applied to these small owner-occupied establishments. They had a strong associational claim. The state shouldn't be able to tell you who you can or cannot let into your own home. But when it came to running hotels or motels or running public transportation systems or engaging in something that really was in the stream of commerce, your associational claim was really quite weak, especially compared to the burden of segregation and the historic burden of segregation on African Americans for whom racial discrimination had effectively denied them the right to travel. So if you run a hotel, if you have, if you're running a business, you're in the stream of commerce, I think in those cases it's more than appropriate. It's often necessary for the law to step in and say, you know what, you don't really have an associational claim as an employer of a large business or even a business that employs, more than 3 people. You're not in business to engage in private associations. Now, the trouble comes, and we've had problems with this under U.S. law too, when colleges and universities, for example, try to apply their anti-discrimination policies to private student associations. And I take it you've had these issues arise here as well. We've had the cases come up with these groups called Christian legal societies. Christian legal societies on campus, which had rules that denied active membership to actively gay students. And if they did so, they would be denied official recognition and the perks that come with that on college and university campuses. This case went up to the Supreme Court, and the court held, to my surprise, that colleges and universities should have the power to subject these student associations to their anti-discrimination rules. I thought that was wrongly decided. These were private associations. The fact that they were religious associations, I think, gave them an even stronger liberty interest. And I think they should have been able to write their own membership rules without incurring any sanctions, because membership, after all, is at the core of association. So we still have a lot of debates about cases like that, because what's happened in recent years is that since we have achieved formal legal equality, more or less, for many previously disadvantaged groups of people in employment, in education, there's been a drive to use the law to create social equality. And that often means the kinds of laws that you have here in the UK, your religious and racial incitement law. And those laws really do infringe unduly and really grossly, I think, on foundational rights of free expression, association, belief, And I think they're really quite dangerous. I think I'm going to stop there. My time is probably
Wonderful,
up.
perfect timing. Thank you, Wendy. David.
Hi, I'm just going to put perhaps a slightly different approach to the question. I'd like to make a distinction between law and magic, because not least because Royal Courts of Justice looks like Hogwarts from the outside, and those of us who actually have to work there, it very much is like it on the inside as well. Magic, of course, sorcery, spell-making, was this bizarre idea that words had power, especially if they were in certain types of books with very elaborate binders and pronounced by people in very elaborate robes, in very elaborate rooms, and everybody was deferent towards this sort of pretense. Absolutely silly idea. That sort of thing would never work. But unfortunately, that is more or less what law is. Law, apart from at the extremes, consists of words, and what those words mean and what consequences they have. At the extreme, both in terms of civil law and criminal law, there is coercion. The coercion might be a bailiff knocking on the door to have repayment of a civil debt, or it might be the G4 security guard taking you down to the cells below. But apart from at those moments where the law legitimises the coercion of one person on another, it exists in words, concepts, and intellectual framework. A Martian looking down on us, not aware of jurisprudence, would just see the occasional act of coercion, but not see anything other than just human beings interacting with each other. Laws exist primarily in terms of words and concepts. You cannot point a law book at something and go, "You're banned," and make that thing extinguished. I once wrote a post at the New Statesman, slightly facetiously, saying we should ban banning things. Because when you ban something, you don't point your wand at it and make it extinguished. It will still carry on, but it's just that the consequences of future occasions of it will be different than they otherwise would be. That is why, in principle, prohibitions rarely work by themselves. So, although I'm on the left and although I'm a legal correspondent for a left-wing magazine, I'm not terribly naive or ambitious as to what you can actually achieve with laws. I think anybody who actually has dealt with practical lawmaking and enforcement knows the limitations of using laws to do anything, and often they have counterproductive effects. Equality. Insofar as one can believe that the greater number of people should have the best opportunity to fulfil their lives, do what they want without undue restriction, yes, I believe in equality. I think many people do. But when it's applied to law, it's actually a little bit more complicated. So what do you actually mean when you say the law should be used to make people more equal? Are you talking in terms of substantive law, i.e. black letter law in the statute books or in the common law, which means that people should be treated differently in situations where otherwise they would be treated the same? Then there's a question of enforcing the law. Who can actually sue? Who can actually bring prosecutions? There's a question of who are the defendants. Are certain groups in society more likely to incur certain types of liability just because they are in that smaller group of society? It's a very difficult thing when you start talking about equality and the law. And so, although I would like the law to be used to make society more equal, it's actually not a straightforward thing, or to put it in sort of academic language, it's inherently problematic. But to bring it from the general to the particular, if there is a question about whether, when faced with service wrongly refused, you should have a civil remedy, I will say yes, there should be a tort. There should be a freestanding duty on anybody not to refuse service without good reason. That's a fairly broad assertion, but that's my starting point. The question then becomes, what is a good reason? In this country, we have a tradition which goes back almost as long as the common law of common carriage. Those who operate ferries, those who operated toll roads, those who operated inns had a duty to actually provide a service to anybody who was willing to pay. Part of the irony of the recent situation, what bemuses me, is the idea of Christians asserting the right of innkeepers to refuse service to couples. But common carriage just merely meant that the civil law would get involved, provide a remedy. If you are providing a commercial service, even from your own home, you should not wrongly refuse that service to somebody just because of a certain attribute. The Equalities Act lists various attributes like race, sex, gender, disability, and so on. As a general principle, I think that must be right. There is a question about whether the compensation is too high, or if you actually do have a strong view that Christian bed and breakfast operators should be able to refuse their services, then the Act has schedules full of exemptions. But the fact that people feel unhappy with this particular case does not discredit the general proposition that nobody should have a commercial service withheld from them for a bad reason.
Thank you very much indeed. Alex.
Thanks very much. I'm going to talk a little bit about freedom of speech and about freedom of thought and expression. It seems to me, picking up on Wendy's example, that if clubs and associations, I think this is the worst end of this debate, but it is happening in the highest court of the land in our American friends' country, and indeed the decision went against freedom of thought in my view. If clubs and associations are forced to admit people who have views which are antithetical to their raison d'etre, that is to say, they have the opposite point of view to the purpose that that club or association was started, then we are making associations meaningless. And you might think to yourself, if you're a sort of very right-on person, you might think, yeah, that's great, so what? These Christians who want to keep out gay people from their law society, they should be forced to disband if they won't admit people who have the reverse point of view. Well, first of all, I'd encourage you to think for a moment whether you think that principle is a wise one, because very quickly you might find that two play that game. And you might find that, for example, Republicans who have a steak dining club suddenly become a fifth column in their vegan society on campus and change their charter. You might find that the National Rifle Association suddenly takes an interest in the Peace Society on campus and changes their terms of existence so that as to encourage use of and indeed purchase of firearms. And I think very quickly you realise that all associations start carrying out this mutual turf war against one another, and there truly is mutually assured destruction. If you won't admit those who have completely opposite points of view to you, then you can't exist on campus. It means in the end, you can't exist on campus. And I think that's a bad thing. I think we start to impinge upon people's ability to discuss ideas in groups. That as a basic principle, in my view, must be wrong. It must be wrong that we impinge on people's freedom of thought and freedom of association in that. And I accept the consequences of my philosophical position, which is that people will be around in society expressing things that I find repugnant. Oh well, people might be expressing things in society I find deeply offensive. I don't believe that you should have a freedom to avoid offence in this country. And that's one of the reasons, I know this is not the topic we've been set today, but that's one of the reasons I support the campaign to amend the Public Order Act to remove the word insulting from it. I think we should have a freedom to insult in society. I think that's an innate part of freedom of speech. But let's and I think on that at least the panel agrees. But let's think about something that we might not agree about. A man now dead who you might have heard about called Harry Hammond used to hang around street corners with a sign saying homosexuality is a sin. And lo and behold, Harry had his collar felt and was arrested by his local constabulary. And the first person to his defence, much to his credit in my view, was Peter Tatchell. Peter Tatchell said, if you start interfering with his freedom of speech, if you try and make people equal in the law so that they can't even be have their feelings hurt by seeing a sign held up by someone doing something peaceful like this, then what happens to my freedom of speech? Because Peter, so you might agree with that part, Peter then went on to say, because next week I want to go down to Muslim Expo, which they'd hired out Wembley for the first time, and I want to hold up my sign which says Islam kills queers. Now, you might think that both of those gentlemen were behaving in equally sort of childish ways or equally unattractive ways about people's deep-held faiths. But the point that Peter was making, and it's one I agree with, is that freedom of speech for one person and the protection thereof necessarily is bound up in your freedom of speech. His freedom of speech to express something you might find unattractive is necessarily connected with the protection of your freedom of speech. And so, to draw on to the things we've just been discussing in David's remarks, as a result, I find myself on the opposite side of the perspective, even when it comes to commercial services by Christian bed and breakfast owners. And my view that the much maligned Chris Grayling position on B and Brie owners, you remember he was taped illicitly in a think tank event, saying something that until recently would have been mainstream conservative philosophy, but there we are. I thought his position was correct, which was that generally speaking, we shouldn't have on any more big hotel chains not admitting people that have different views to them. That's not the sort of society we might want to live in. But people admitting them into their own homes, it's wholly disproportionate to start wielding the force of the law against those Christian homeowners. I must also add, I think it's fabulously unlikely to change their views. I think it's a remarkably unlikely way to seek to change minds and attitudes. But even if I'm wrong, even if the law can make you equal in some aggressive way, I think that there are worrying ramifications for your freedom in society. So, for example, I can think less of someone who dislikes black people or dislikes gay people, and that's the punishment for him. Without curtailing his thought or expression, I can argue against him in the free marketplace of ideas, and because his arguments are not logical, I would hope that I would win. If he's basing his views on prejudice and I'm basing my views on fact, I would hope that I or someone else who's better at arguing would win. And the answer is not to curtail and drive out speech or acts that you disagree with, because ultimately that simply means that that act or speech carries on away from the eye of the law and away from society at large, which is deeply unhealthy. If you want to affect societal change, then you have to argue for that change over time. That, in my view, is a much more likely way to succeed.
Thank you very much. Get a round of applause. John.
Luke asks us the question, is the Equality Act and other legislative and legal developments in promoting equality denying key freedoms? And that obviously invites us to ask, what key freedoms have we got in mind and what sort of equality have we got in mind? It's such a big and complicated picture that I really don't think this is a case where the devil is in the detail. The devil is in the bigger step back and have a look what's going on picture, I think. I mean, there is devil in the details. Just to take some of the cases that we've been talking about, I thought Mrs. Ueda was rather picky about insisting on wearing a cross when she was on the aeroplane. And I thought that British Airways were rather picky in insisting on their uniform and not letting her wear her cross. I thought that Mrs. Chaplin, the nurse, was rather picky about wearing a crucifix when the uniform changed as a nurse to a V-neck, exposing the crucifix. And I thought that the NHS was rather picky in insisting that she didn't then wear her crucifix. I thought that Mrs. Liddell was rather picky in Islington Council in not agreeing to officiate at civil partnership ceremonies. And I thought that Islington Council was very picky when it didn't accommodate her by getting somebody else to do it, as it so easily could have done. I thought that Mr. McFarlane was picky, when he said, I'll talk to gay couples, but I won't talk to them about sex. And I thought Relate, the employer, was rather picky when it said to him, well, you lose your job, even though you've now said you will talk about sex to them, because you don't believe you are going to talk about sex to them, as happened in that case. That Bull, Mr. and Mrs. Bull, I thought they were rather picky in saying we won't have gays. And Mr. Hall, going round, knowing that they were doing that, knocking on the door and saying, will you take me in for the night in your B&B? They were both rather picky. I thought Mrs. and Mrs. Johns were picky in not saying to Derby Council, what I want to do is, in my belief, I don't really think gay people are doing something that's right and moral when they live together. They were applying for fostering, and I thought they could have been diplomatic about their beliefs. And I thought Derby Council was picky when it said, we really want to know more about what your religious beliefs say about your accommodation of homosexual practices before we allow you to become foster parents, and so on and so forth. A lot of devil in all that detail, I think. I mean, how absurd. How absurd that the law is getting into that. And when I said you step back and look at the big picture, let me just give you this example of the big picture. The 2006 Equality Act sets up the Equalities and Human Rights Commission. The Commission shall exercise its functions with a view to encouraging and supporting the development of a society where people achieve their potential, not limited by prejudice. There's respect for and protection for each individual's rights. There's respect for the dignity and worth of each individual. Each individual has an equal opportunity. There's mutual respect between groups based on understanding and valuing diversity. Well, talk about magic. The equality, and that's their first, and moral-led duties. They'll promote understanding of the importance of equality and diversity. They'll encourage good practice in it. And then in the 2010 Equality Act, more big picture. This is the Equality Act that starts out with a duty, a public sector equality duty. A public authority must exercise its functions having due regard to eliminate discrimination, harassment and so on, advance equality of opportunity, foster good relations between persons who share a relevant protected characteristic and persons who don't share it. Well, I'm not mocking that a local authority should do that, but for heaven's sake, do we not expect local authorities to behave in a way where they would conduct their business and their activities in a way that enable people and facilitate people to get on with each other? Also, in that Act, in the Equality Act 2010, public sector duty regarding socio-economic equalities. An authority to which this section applies when making decisions of a strategic nature must have due regard to the desirability of exercising them in a way that is designed to reduce the inequalities of outcome which result from socio-economic disadvantage. Wow. I mean, that's magic plus, isn't it? If your local authority can do that, reduce inequality of outcome due to socio-economic advantage. Subsection 6 gives them some let out, however, because subsection 6 says you don't have to do that if the inequality experience is a result of a person being subject to immigration control within the Immigration Asylum Act of 1999. The point is that all law against discrimination has started on the basis of restricting choice. Because, of course, to discriminate is to choose. To discriminate is to have a view. It used to be thought if you were discriminating, you were a really, rather sophisticated person. To discriminate now is automatically seen to be wrong. Well, it started out by saying you can't actually choose to treat somebody else less favourably on certain grounds in certain conditions. You can't say no Irish, no blacks, no dogs if you're renting a property. You can't do that. You can't employ somebody or not on the basis of their colour or their religion or their colour or their nationality or ethnic origin. And then it grew. And what started as an attempt to use the law to protect people in that way and to give what we would understand as a civil rights in a broad sense, it's changed. I mean, now you've got 8 protected characteristics. Age, disability, gender reassignment, marriage and civil partnership, race, religion, sex, sexual orientation. And all of those are now in play. And with these overarching requirements, what we are seeing is this. It's a massive attempt to tell people how they should behave. And how they should behave in some really frightening detail. It goes to free speech, it goes to all their personal activities. And you can always argue in every particular situation, one way or the other, like those examples that I gave you. What you've got to say is, it isn't the business of the state to be doing this. There's obviously a problem here if they're trying to, but this is not the way to fix it. What they're doing is they're trying to patch it up, and indeed, not so much maybe patch up the problems that exist, as to patch up a problem that they themselves have, which is a problem of authority and legitimacy and, the ability to command some loyalty and coherence and to set out some direction or some values by which they think society, around which they think society should be cohered. And if you don't like it, you better lump it. Very interesting word that's used in the Liddell case, just slips out by the judge. He said Islington Council is entitled to take that woman, to sack her for not carrying out civil partnership. In just about it, he said, because what she believed was not mainstream thought. Not mainstream thought. That's, to me, a good example of the extent of the danger that we're talking about.
Thank you very much. Can we have a round of applause for our panel? Okay, so I've got 2 quick questions. The first is for sort of this 3 here, because broadly there's a consensus, I think, roughly, that generally these actions which seek to or regulate against discrimination are a bad thing. But that necessarily demands quite a strong defence of our right to discriminate and the right of private organisations to discriminate. And I think Wendy drew a very helpful distinction between public and private organisations. But, John, I think that the law has to be picky because it does depend on being applied to a very specific set of circumstances. It's applied on a case-by-case basis. So with that in mind, there's a very simple question, and that's, do the people who are making your argument think that organisations such as a hotel or any employer should be able to discriminate against people on the basis of their race, disability or gender? Should they be able to not, should that be a ground upon which someone is refused employment? And should there be a legal remedy for those who find themselves at the rough end of that? Now, part of me thinks it's a hypothetical question because it's unlikely to happen in society today, but it's an important question as to why the law should exist. And then for David, I'm wondering whether you could say a bit about what you think the relationship is between the law and the way that society shifts. Is it that the legislation reflects changes in wider society, or is it that the law takes a lead in bringing about that change?
I think I'm going to address both questions, really, because I think they're related. When Lyndon Johnson was in office in the mid-1960s and was largely responsible for pushing the 1964 Civil Rights Act through, and he reportedly said, this may be apocryphal, but it's a good line anyway, he said, "Law can't change what's in people's hearts, but law can lead the way." Now, Luke, you asked, should the law prevent people from discriminating in employment, in public accommodations? I think absolutely it should. And in fact, that's now pretty much settled law in the United States. Very rarely will people who might have opposed civil rights legislation 50 years ago express public opposition to it now. But the law should not try to go the next step and regulate the way people talk to each other, the way people treat each other in their private associations, in their interpersonal associations, as Alex and John have been saying. When can the law try to coerce cultural change? What's the relationship between law and culture? You know, I think the most stable and certainly the most peaceful legal changes, if we're talking about extensions of non-traditional rights, follow from cultural change, but sometimes law does coerce change, and again, the civil rights movement is a very good example of that. I think in the blurb to this panel, there was discussion about there being a mass movement for equality that went along with the movement for racial justice in mid-20th century America, and that's really not right. There was no mass movement for equality. The civil rights movement was legally coercive. In 1954, when the Supreme Court barred racial segregation in public schools, there was no mass movement for it. That case came about because of a concerted legal strategy developed over the years by a small group of lawyers and activists. It was a decision made by 9 justices. It was highly controversial. It took a long time to implement. When the Civil Rights Act was finally passed after some years of some serious violence, really serious violence, murderous violence in the South, because there was enormous violent resistance to change, and it was coerced by law and force of arms. It was coerced by the National Guard, and it would not have happened any other way. And over time, over the decades, culture incorporated it. I just wanted to say a few more words about free speech and where we draw the line between what law can force you to do and what law shouldn't try to force people to do or to say. People have a right to harbor their prejudices. I absolutely believe that. They don't always have a right to act on them. So I support laws that prohibit people from discriminating in employment. I strongly, strongly oppose laws that tell people how they should talk to each other, that make it a crime or a tort to insult or offend people on any basis whatsoever. If you don't have freedom of speech, you really don't have freedom of belief. I think these hate crime laws really are thought crimes. I think in a relatively free society, you have a formal legal right to offend people, and you have an informal right, an informal obligation to take it.
Thank you, Wendy. Because I want to get out to the audience quite quickly, and we are going to stick quite strictly to time, if the panel could keep these remarks quite brief. Alex?
Sure. I think the law follows societal attitudes. And I think that views on, for example, gay people's positions in society were way more liberal than British law by the time the law changed. Equally, laws on the rights of women in British society. It was legal, ostensibly legal, to have rape within marriage until exceptionally recently. But most people would have thought that was a straightforward crime, and the law lagged way behind social attitudes. And of course, a single generation ago, hotels were still refusing accommodation to unmarried people, let alone gay people. So I do think that there is something to be said here about the importance of social change over and above the law. I think the law generally follows the fact. But in answer to the question you posed to us, Luke, which was about what do we do or what do we think when organisations have different attitudes to those that are, in John's correct words, against mainstream attitudes, should we legislate against it? My view is always we should try to think first of all about the reality of the situation. So, for example, Catholic adoption agencies, which were placing in this country many hundreds of children into loving homes, the vast majority of which the adoption process is touched not one bit on homosexuality in any way. If you ask the campaigners against Catholics being able to do that because of their position on homosexuality, would you rather those children went to loving homes generally or in Catholic homes, or we took an absolutist view? The view, it seems to me, is we would rather have the absolutist view, and Catholics cannot adopt per se as long as they hold these unacceptable and illiberal views on homosexuality. But when your absolutism is more important to you than reality, I think something's desperately wrong, and it's not wrong with those trying to adopt people, it's something wrong with you.
Thanks, Alex. David?
The legal process is very good at one thing, which is determining legal issues. That's almost tautological. But the legal process is there primarily to decide questions of liability, whether somebody's acting within or outside of their powers. Fairly narrow questions. Where things start going wrong is where the legal process is put to wider issues. I've done a lot of work in libel. The libel court was not the right forum for deciding whether chiropractic worked for children or not. It wasn't the right forum for deciding whether David Irving was a scholar or a charlatan. Yeah. It was not the right forum for deciding whether various post-Marxist journalists got various things about Serbia right or wrong. It is just not the right forum. Law is a very useful thing if it's used for the purpose, which is deciding liability. Law and social change. Well, sometimes the law reflects, sometimes it leads. There's no monocausal relationship between law and social change. There are people who adopt a definition of Toryism, which is to defend the Whig victories of yesteryear, but not the ones they want today. Yes, civil liberties and equality was brilliant until about 5 or 10 years ago, and now it's all horribly going wrong. Well, actually, there's a more problematic relationship between law and social change. It is only at the margins, generally speaking, that the law resorts to coercion. Law is part of a bundle of official actions like, for example, policy making, expenditure, prioritisation of what is done with the armoury of the state. Law by itself will never affect social change one way or another in general circumstances. And as regards bed and breakfasts, people who operate a bed and breakfast service from their own home have no defence to HMRC by saying, well, I can't pay my taxes, it's in my own home. They have no defence to health and safety if they leave electric wires such that the rooms could actually lead to people dying. They can't say, no, it's my own home. If they are going to be sued by people for not actually fulfilling the terms of their contract, they can't go to the district judge in the county court and say, sorry, it's my own home. Bed and breakfast operators are already regulated by the law in a number of ways to which their it's my own home is no defence at all. And equally, it should not be a defence if they wrongly refuse a service to people who wish to pay for it.
Thank you, David. And John?
Just very quickly, responding to what Wendy said, I mean, I would reserve my position on, the civil rights legislation, leading and being responsible for changes in attitudes. And I think it's beyond the confines of this debate, but I think the key to it really is your comments about the role the National Guard played, and we see that from what the FBI did in, going mob-handed down to Mississippi to try sheriffs for the murder of civil rights activists. That it wasn't so much a law leading it; it was the iron fist of the state, if you like, asserting its authority, down in the South at that time.
To keep people from being lynched.
But I wanted to say this about it, though. Even were it the case that the state were doing that, I think we should be suspicious of it. It isn't the role of the state in that sense. I mean, as David said, it's sometimes behind, sometimes in front. It's a dialectical relationship as the law proceeds. But, when it gets to the state that it is today, that the position that we have today, that the state is playing such a proactive role, as it were, in shaping the attitudes in this way. You feel like Sam Goldwyn. If you want to send a message, please use Western Union. Don't use the law. Don't use the law to send a message to the people to tell them what should be mainstream and appropriate and acceptable behaviour. And that's what we've got. And I think if we begin to see that that's what's happening, and to question the legitimacy of, this isn't a question of even the law catching up with what people are thinking. As Alex makes a point quite rightly, I think, about changes with regard to homosexuality, to abortion, of course, was wholesale. Before the 67 Act, the changes in practice. This more recent things with the Equality Act isn't a question of the law catching up with, even attitudes, or even, it is really about promoting, ideas of acceptable and appropriate behaviour. Great example, of course, is the proposal to bring forward gay marriage. Nobody was talking about bringing forward gay marriage until David Cameron put it on the agenda, as something that, one feels profoundly that David Cameron thought would benefit the Conservative Party at a time when it was looking around for something to be seemed to be progressive on and seemed to be dynamic about.
Thank you very much, John. All right, so plenty to think about, so I'm going to come out to the audience.
I wondered on the panel's opinion in respect of the protected characteristics, something which I've turned over in my mind and have reached no position on. All except religion are not a matter of choice. You can argue about sexuality, but generally speaking, you do not choose to be female, you do not choose what colour you are, etc., etc. You do choose what faith, lack of, etc., belief you have. I was just interested to see what people's views on that was.
Yeah, if I can start with a disclaimer just to make clear that I'm not a lawyer, just so everyone realises that. In fact, it does have a bearing on what I'm going to say, because I'm actually writing a book on, not on legal equality, but on the discussion of social and economic inequality, which is clearly not the same as legal equality, but I think it has some bearing at the same time on this discussion. Because the one thing I've become absolutely convinced of in the course of the work I've done so far is that the way the discussion is usually framed, which is freedom versus equality, or perhaps you're somewhere along the spectrum, is absolutely wrong. We shouldn't take that framing of the discussion. That really confuses things. I'm not accusing anyone of the panel of doing that, but that is very much the way that it's very often framed. Because it seems to me what the dynamic is at the moment is certainly anti-freedom, but what's really going on is what I would call the therapeutic management of inequality. So in other words, the elite, if you want to call them that, are so worried about society being diverse, about it having all of these different interests, about it fracturing on all sorts of different lines, that it wants to use the law and other kinds of measures to try to cohere society, to keep it together. And that's precisely also what, to me, makes it so authoritarian. That this fear of social fragmentation, the lack of social capital, the lack of social justice, whatever term you want to use, they use all sorts of different terms for it. This fear of social fragmentation and the intense anxiety and desire to pull everything together is precisely what it makes it such a dangerous and authoritarian trend.
I just wanted to take up this argument that the home is already regulated, therefore it doesn't matter if it's regulated more. If you read Stanley Fish, this is precisely his argument against free speech, that speech is already regulated, it's called grammar, therefore it doesn't matter if it's more regulated, because I submit my articles and they get edited, it doesn't matter if I can't read or am allowed to put certain books in the library. It doesn't matter because publishing is already regulated.
One comment that David made, which I do agree with, is when he said that his argument sounded tautological. Indeed, it didn't just sound tautological, it seemed to me it was tautological. Because what you were really saying is that because something is illegal, there needs to be a legal remedy. Now, you recognise the difficulty with that argument, so you tried to justify it. and you did it by saying, well, because the state requires us all to pay our taxes, that means the state must presumably, on your logic, have the right to intervene into just about any aspect of life that goes on in the home. Well, you're shaking your head, but you see that your argument about paying taxes just doesn't work. Because I think a useful starting point here is to say, is there a social need for the state, through its legal system, to get involved in regulating an area of activity? Now, plainly it does in terms of paying taxes. You cannot have a society that functions if there isn't a legal obligation to pay taxes. There is no such legal obligation on hoteliers to take in people who are gay. I just think there is a failure to understand the extent to which society has changed. The background to the first race relations legislation in this country was signs in estate agents' windows that would regularly say, no blacks, no Irish, no dogs. You simply would not get that sort of sign in an estate agent's window now. And that's why, despite the fact that this legislation has been on the statute book for many years, there have only been 2 cases of hoteliers turning away people who are gay. And as Alex pointed out, one of those gay couples had to go hunting around to find some hoteliers who would turn them away so they could make a legal case about it. And again, with Lillian Liddell, the Islington registrar, there was no difficulty with her colleagues covering for her so that she could avoid carrying out civil partnership services. So I think that society has changed and the law is now playing a wholly different role. It is not tackling a systematic problem that needs to be tackled. It is doing actually quite the opposite. It is interfering with the individual rights and with freedom of expression and association, and that is a far more serious problem.
Okay, I'm going to have the panel respond to that and then come back out. I'll start with John this time.
Well, I'm surprised. I completely agree with what John Holbrook has just been saying. I said before that I thought it was important to look back, to look at the big picture, and I think John's been doing that just now in terms of what the different things that the law is doing with regard to social existence with its discrimination legislation. One factor I think we have to include in our consideration of this is the increased role of the judiciary after the Human Rights Act came into force in 2000. Because there was a step change there. I mean, not simply on account of it being the judges, that was an issue all on its own. Not just about the fact that it was the judges who were elaborating where the lines and where the detail of the law fell in particular cases, but because they were doing so, as Lord Irvin said in moving the Human Rights Bill in '97, in future our judges will determine the law on a more moral and principled basis. And, of course you ask, whose morals? Whose principles? Yours, Derry Irvin, or the new Labour government, or the judges that we have. And that gave, and of course the way the Human Rights Act incorporated the Convention rights of the European Convention, gave the opportunity for the lawmakers, then increasingly the judges, to intervene at the level of detail that we see, actually examining the different aspects. You asked about the question about should religion be there because it's a matter of choice. And I don't feel almost equipped to answer that question because that's choice unlike the others that are given. But what I do know is it isn't really the responsibility of 3 or 5 judges to be saying what the answer to that question is. And increasingly, when that is considered, not so much in the context of protected characteristics under the Equality Act, but under Article 9 of the European Convention, which defends thought, conscience and belief. And they're saying, well, it is protected if is it your core belief? Is it a core part of your religion to wear the crucifix or the jilbab or the hijab? Is it a core part of your religion to pray at a certain time? And maybe we'll protect that. And then beyond that, the European Court of Human Rights goes on to say, is it worthy of respect in a democratic society, what your philosophical conviction is, what your belief or religion is? And so, it takes all those together, and I think they should be taken together.
Thanks, John. Alex?
In answer to your point about compensation for the couple and the gay B&Bs and so forth, I did think, first of all, what's the loss? and there are about 5 or 6 other B&Bs on the street that would have taken your trade. But moreover, my point about, and I wouldn't be stupid enough to turn away custom, but secondly, my point about the kind of mutually exclusive arms race applies here too. If you consider Kemp Town in Brighton, which is a fantastic, vibrant, very gay culture, Camp Town popularly called in Brighton, there are plenty of B&Bs in Brighton where lots of people from all over this country go to enjoy themselves, and good on them. And the B&Bs that they go and stay at are rainbow flagged to the hilt. They have gay welcome signs. They are gay, gay, gay. They are gay places. And what are we saying? If 2 arseholes walked in, crucifixed up, and said, "Hello, we're a nice straight heterosexual couple. We'd like to stay here, please," are we saying that they should get compensated if the gay runners of this gay hotel said to them, "I'm not really sure this is for you"?
Thank you. Wendy.
Quick comment to the woman who asked the first question about fixed characteristics. It's a sort of a basic principle of U.S. discrimination law that it's supposed to apply in cases where people are discriminated against on the basis of immutable characteristics, which is one reason that the gay rights movement pushes so hard for the notion that sexual orientation is not simply a matter of choice. And it's also why, as people try to expand the categories, so that now obesity, in the view of some people, is supposed to be included as a disability, you'll hear arguments that people don't really have a choice about being obese. It's the way they're genetically programmed. And we are getting longer and longer lists of people who have protected or immutable characteristics under law, so that, past a certain point, if everybody is a member of a protected category, and if everybody is a member of a previously disadvantaged group, the discrimination laws become, I don't know if meaningless is the right word, but it becomes like a kind of self-satire. Now, I just wanted to respond quickly to John's rather snide comment about the heavy hand of the FBI during the Civil Rights era. Not that I have any love for the FBI, and most of what they were doing during the Civil Rights era was spying on Martin Luther King. But it's important to remember that in those cases, the state was not dealing with merely unacceptable behavior or trying to get people to be nice to each other. People were being murdered for trying to exercise their right to vote. People were being murdered for registering people to vote. In those cases, I think it's it's more than appropriate for the state to step in. And in those cases, we're not really talking about discrimination anymore. We're talking about something very, very different. And finally, to David's point about all the regulations to which these owners of owner-occupied bed and breakfasts are already subject to, I think that's really irrelevant, because in this case, we're talking about a regulation that directly violates their right of association. A health and safety code does not violate your right of association the way these laws do.
And David?
On religion as a characteristic, I agree with you. It should not be on that list. Simple as that. And you've identified the qualities which mean that the other ones should be on that list. As regards Stanley Fish, who I've never, ever been asked about before, and I think I may well be the first lawyer ever to be asked about Stanley Fish, but in this country, speech is actually regulated in your own home. There's a whole range of possession offences to do with certain materials, especially pornographic materials and materials which go towards preparation for terrorism, which you could perhaps even argue, well, it's speech in my own house, but actually the law does intervene. I'm doing a book at the moment on privacy law, and my first chapter is the sheer amount of offences you can commit in a room by yourself, even without any electronic devices. It's astonishing. But it's a thin red argument. I was hoping to be clear by saying commercial services are regulated. They are inherently regulated. The very notion of commercial exchange is a regulated activity. You need to be able to go to a court to enforce your contract. If you are buying and selling property, you need to be able to go to a court to establish title to that property. You cannot have commercial activity without regulation, other than the most basic barter system. Once you start saying contracts should be enforced and you can buy and sell property, you are at a stroke saying commercial activity is regulated. So I'm afraid I must disagree with you. The thin end of the wedge, Stanley Fish says this argument does not. I'm specifically making comments about commercial activity, and that is regulated in your own home or anywhere else. As regards the argument which was put forward that I was arguing a tautology, I actually said so. I am glad you agree. You know, the legal process is good at dealing with legal issues. That's the point. But there is a tradition of common carriage in this country, in the common law. Innkeepers, ferry operators, bridge operators, toll booths could not turn people away if they were willing to pay for that service. Anybody that prides themselves in wanting old-style law, that is old law. That was the law of this country. I'm just saying this should be updated. If a commercial service is wrongly refused, question what is wrongly refused, but just as a matter of principle, then yes, you should have a civil remedy. Shouldn't be a disproportionate one, of course not. And it should be one which actually serves the purpose of that, correcting that wrong. But is it wrong? Should the law have a role in that? Yes, I think it should. That's what torts are for.
Great. Thanks, David.
Wendy, I just want to pick you up on the civil rights law. I know the American left are very attached to it for all kinds of romantic reasons, and it's not negotiable, but I do think there's a couple of big problems with it. One that John's alluded to is that while the civil rights law did reflect a desire for freedom, a desire to end certain types of oppression, all kinds of progressive ideas that I have an awful lot of sympathy with, and a lot of the American population were behind it, there was a big chunk that weren't, and they were forced. You didn't win the argument. And yes, you can say they were committing crimes, but crimes could be prosecuted. But the people who were in the Ku Klux Klan, who were organising their meetings, they weren't committing any crimes at those meetings, and yet their names were recorded, their number plates were recorded, they were disrupted, you know, and that was the disruption of a free association, a political process, which is bad. But I think perhaps a more interesting point is that while the law did reflect a desire for freedom to some extent, it also kind of hijacked that desire for freedom. So it took it out of the hands of people who were on the streets fighting for it, where it belongs, and put it into the hands of lawyers, where it doesn't really belong, and codified it, and turned it into something that was not really about popular expression anymore. And if you fast forward 50 years to today, I'm wondering, and this is really for the whole panel now, are we getting the law today that we deserve? Because we don't have that desire for freedom anymore than we did in the 60s. We have a desire today to regulate and control people. We don't trust people. We don't trust free assembly. We don't trust people who have political ideas, strong ideas. We don't trust people to get on at work. You know, everywhere you look, we basically don't trust people to get on and do the right thing and be robust and have the kinds of arguments that I think the people in this room would like them to have. And maybe the law is actually reflecting that in the same kind of way that the law of the 60s reflected something better.
I'd be interested in the panel's thoughts on just a couple of points. If people can't choose to be racist, can people choose to be not racist? And if people can't choose to be anti-gay, can people choose to be pro-gay? I feel like what the law is doing is taking away moral relativism and some moral nuance with blanket regulation that's sort of made for people in response to bad things in order to stop bad things from happening. But the fact is that as a society betters itself, society advances and manages social problems or injustices in positive ways, and that is important. To what end do we want the law to make us equal? So I'm not really sure that I want to live in a truly, purely good, morally good and equal world. Badness and wrongness lead to good and positive things on the way to progress and change, and that process is important for being human and civilized. And the fact that there's, for example, anti-gay sentiment means causally that there's impetus for gay rights movement, gay rights activism, finding collective moral spirit, sharing in the expression of that moral spirit. And basically, moral wrongs are intertwined and often responsible for moral goods, and I don't feel like the law accounts for that nuance.
I'm actually a former law student of John Fitzpatrick, and hi, John.
Save it.
I was always taught that the purpose of the law was, incidentally, to protect freedoms and not to enforce social mores. So I was particularly interested in Alex's point with regards to the adoption agencies. Many of which, incidentally, have in fact withdrew and stopped placing some of the most vulnerable children that have been placed up for adoption, rather than act against the consciences which motivated them to perform these services in the first place. My concern is if the law imposes or decides which views are palatable and which are not, society is at serious risk of further services which the state is perhaps not in the best position to provide, or at least not to the same standard as in the private or charitable sector, that they're going to lose these services as well.
I'm assuming I'm thinking about this incorrectly, because the more I think about this, the more I'm trying to, in my head, thinking we shouldn't have any laws, virtually. So there must be a problem somewhere. And I'm trying to think about this in terms of John Stuart Mill's harm principle. And most particularly because, very much like Stuart Derbyshire, the guy with the glasses down there, was saying in terms of the problem of a political culture being undermined by the legalization of everything. That's the kind of obsession I have at the moment. And I'd love there to be a political, moral, vibrant, active being the key word, culture. So I'm thinking, well, bed and breakfasts, yeah, there shouldn't be a law against that. Well, what about hotels? Why should a private individual who has a hotel have laws telling him who should go into his hotel? I'd much rather that people didn't go, that I could campaign against him, that I could organize a union, that I could say it's morally wrong, that I could be, he's not harming me directly, but I would disagree with it passionately, and I could get out in the streets at last, thank God, and try and convince other people and have some arguments and a few fights, hopefully. As I get older, I want to become more violent, it seems. And seriously, but then I think, well, what about employment law? Should employers be forced, private employers, if they're public, it's public money, we can vote on it, and you should do what the public say collectively. If it's private money, should they have to follow prescribed legal who you should and shouldn't employ? I'd rather have to say, well, let's organize against that, let's have, and so on. So in that sense, in my head, I'm thinking, well, actually, all these laws should be down the toilet, because they're actually restricting people from creating a political, moral culture where you fight for what's right and wrong.
A point was made earlier from the audience about the fact that we don't see signs anymore that say no Irish, no dogs, no blacks, things like that. I live in East London, and what we do find a lot of is signs that say Muslim only, female only. So we do still have a lot of division within society. Now, if we do what the gentleman over there was saying and get rid of all these laws and say it's every man for himself, we're going back 200-300 years where every man for himself ended up on the streets, under bridges, and in abject poverty, because the only people who could get anywhere were the people who knew people, not the people who were the best people for the particular jobs. There is a problem with equality laws where you have quotas that say 25% of your workforce has to be black, because you are then saying that, sugar, I need to employ black people, whether they're the best person for the job or not. So it's the implementation of the law that is the problem, not the law itself.
I'm going to invite the panel to sum up in 1 minute each, if at all possible. David.
The notion of unregulated hotels. If it wasn't for the building regulations, the hotel would probably fall over. As regards blanket regulation, it's one of those pejorative terms. The only people in favour of blanket regulation are the regulators of blankets. It is one of those terms which, of course, nobody's in favour of blanket regulation. Everybody wants to have laws which serve the purpose which laws can do. Do we have the laws we deserve? I suspect every generation, ever since the Mesopotamians actually set down the first code in writing, have said that the law should be better, or the law was better, or will be better. The fact is that some of the law works, some of it doesn't work, and it's a constant exercise of improvement. As regards equality, law is there in the last resort. The best legal philosophers, the positivists, point out that all law is an attempt to predict what a court does. Nobody wants to go through life, unless you're a litigator, going to court a lot. It should be there in a case where there's a dispute and it determines a legal question. So the best situation, it seems to me, is to have a society which does not feel the need to resort to litigation, but if litigation is sadly necessary, that the courts will uphold laws which will allow us to have a free and equal society where as many of us as possible can realise ourselves.
Wendy.
Well, I don't think I've ever before been accused of romanticizing civil rights laws. I'm usually accused of romanticizing free speech, so I thank you for that. It's not just people on the left who are attached to civil rights laws. It's people on the center. It's really a strong majority. What you will hear from some people on the right, and it's mostly the free market advocates, is that all of these changes, not just changes in, not just anti-discrimination laws, but maximum hour, minimum wage laws, child labor laws, that all of these changes would have happened without the law. I don't happen to believe that. I don't think it's a coincidence that all of these changes only happened after laws were passed that required them to happen. I think the notion that civil rights legislation took away the power from people in the streets is absolutely nonsensical, no offense. The people in the streets were demanding legal change. That was what they were fighting for. And in fact, segregation was not simply some cultural phenomenon. It was enforced by law. There already was law in place. They were demanding that the law be changed. They were demanding that the Constitution be construed so that the 14th Amendment equality rights extended to African Americans and others in various ways. I don't agree that there's no more action on the streets. We do see a lot of action on the streets. We've seen it with the Tea Party to some extent, though they were smart enough to be political. We've seen it with the Occupy movement, which was not smart enough to be political, and we can see where that went. But you know, remember that this movement didn't happen in the absence of law. It was an effort to change laws that were already there. Finally, I simply want to say that I think, what was the phrase? Therapeutic management of inequality. I think that really is a lovely phrase, and I thank you for it.
Alex? Well, I agree with Wendy that the law can stop discrimination by the state. That is to say, you can change previously discriminatory laws, so removing policies of negative discrimination like segregation in schools, but that's changing the law from discriminating to not discriminating between individuals, and the state should just leave us alone, more or less, I think. But more widely, and I'm certainly not in favour of positive discrimination, whether that be for university places or for positions in the workplace. But more widely, I think that views change, then the law. And trying it the other way around leads to these views that you disapprove of being held illicitly. Banning people from expressing their views doesn't mean that their views have changed. Instead, they are most likely to have had their views repressed from public discourse, but they fester elsewhere in secret meetings, which probably feel sexy and espionage-ish by dint of their repressed condition, and they come with a dollop of martyrdom to boot. And if you want to help the BNPs of this world, then banning their views and telling them they're against equality is exactly the way to go about it.
Only John.
Personally, I wish I'd never mentioned the Civil War and the civil rights movement.
Well, it was a civil war.
Don't mention the war.
That's the code. That's my code. The civil rights. I just want to say about that. You know, I cheered Gene Hackman in Mississippi Burning. Yeah. I mean, and that was the point I was making, really. That it was the state, the northern state, effectively. It wasn't about it was enforcing the criminal law about people who were not prepared to obey it in the South. They were killing people, and they were stopped from doing that by the iron hand of the state. That was the important development at the time. And I'm sure that had all sorts of effects, beyond that. But that was the crucial thing that happened. The need of the state to impose its authority and will in an area where they were just simply killing people was a very important part of it. Secondly, on the question about should we, just abolish all these laws, well, I'm a complete extremist, and so a bonfire of the vanities, I'm completely with that. A bonfire of the lot. But I don't know who was it who said, I'm an extremist, but I hold my extreme views very moderately. So I think we ought to abolish them more slowly and move in that direction. And it's about moving in directions, and that's where I completely agree with Wendy about, well, there are things happening, and if they aren't happening, we should be making them happening on the street, and certainly not with the Tea Party or the Occupy movement. It's up to us to make them happen, and to keep talking, keep acting, keep organising, keep having these discussions, keep making these interventions, so that the agenda is not taken as it is being, by the people who are bringing forth this legislation and all these measures the intrusive measures, the authoritarian measures that we're talking about. I finish an old quote from another American lawyer, Learned Hand, in 1945. The spirit of liberty speech, always worth repeating. Liberty lives in the hearts and minds of men and women, and if it dies there, there's nothing that laws and constitutions and courts can do to save it.
Please.
Well said.